You didn't know when I was coming back? I had to call the office. Always a problem when you're not there. So. All right, we are all present. Let me remind the media, so you can only record or stream when court's in session when I'm on the bench. So if I'm off the bench, there shouldn't be a recording. All right, and let's make sure it's clear for everybody. What are we going to argue today?
We're going to argue a lot, Your Honor. We're going to talk about the statement to Bazinet, the consent to search to Bazinet, and the search of the house, search warrant.
All right. Y'all agree that's what we're arguing?
I think so, yeah.
Yes, sir.
Go ahead.
Your Honor, starting with the consent to search, I'm sorry, starting with the statement to Bazinet that you looked at, the issue comes out as the voluntariness. Matthews versus the state, 311, Georgia Supreme Court case 531, 2021 case. In that case, Your Honor, he said that in determining whether a defendant's statement was voluntary as a matter of constitutional due process, a trial court must consider the totality of the circumstances, and the state bears the burden of by preponderance of the evidence that his statement was voluntary. Under Dean versus the state, 292 Georgia Appeals, 695, 2008 case, Your Honor. And basically that case says that regardless of the custodial or non-custodial nature of the interview, for statements to be admissible, they must be voluntary. They are admissible if considering the totality of the circumstances. They were made voluntarily without being induced by hope of benefit or coerced by threats. If you watched the video, which you did, there was no hope of benefit given by Bazinet or Townsend, and that he was not coerced in any way by any threats. Under Troutman versus State, Your Honor, which is another Supreme Court case, that's going to be 300 Georgia 616. This is a 2017 case, Your Honor. And in that one, Your Honor, when it's talking about the hope of benefit or coercive threats, when it's going into the voluntariness, he's really referring to coercive police activity is a necessary predicate to the finding that a confession is not voluntary within the meaning of the Due Process Clause of the 14th Amendment. The circumstances of the investigation and arrest in the case reveal none of the extreme tactics identified as the hallmarks of coercive police activity, offensive to notions of due process, such as lengthy interrogation. This was less than a 4-minute conversation. Physical deprivation. He was not restrained physically in any way. Brutality or deception. None of that was in this case, Your Honor. These are techniques and methods which create circumstances in which the suspect clearly had no opportunity to exercise a free and unconstrained will. In these statements they gave, Your Honor, it's obvious that none of these tactics were used to be coercive, to override his free and unconstrained will. In fact, if you look at the jury instruction on voluntariness, which is 1.32.17, this is the law that's given to the jury about voluntariness. It says to be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestion or promise of leniency or reward. A statement made to induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion of any necessity imposed by others. In this case, He's not in custody. He's at his own house. He's not restrained. The guns are not pointed at him. Any sort of restraint, verbal restraint on him, are all phrases that connotate temporariness. I think the phrases used are, "You're not to leave at this moment," emphasizing at this moment. He says, "We're going to wait here until we get one more." Until we get one more. He asks, "Can I use my phone?" And Townsend responds, "Give it just a minute." All these things connote a temporariness to it, not you are in custody. You have not formally been arrested, which is what is necessary for that to come about, Your Honor. A person is deemed to be in custody requiring Miranda warnings before interrogation when he is formally arrested or restrained to the degree associated with a formal arrest. In this case, Your Honor, there was no restraint. One of the cases directly on point is Owens v. the State. This is going to be a Court of Appeals case, 332, Georgia Appeals 525. This is a 2015 case, Your Honor. In Owens, Your Honor, he is a visitor at a house that is being searched. He was actually being lawfully detained in the living room of the house while officers conducted a search of the common areas of the house pursuant to a fourth waiver and a probation order pertaining to his housemate. So the housemate had a fourth waiver for the house. He was actually detained in the living room of his house while they did that. He had not been formally arrested and was not handcuffed. A reasonable person in his position would not have thought that the detention would not be temporary. A person being detained is in custody only if a reasonable person in his position would not have thought that the detention would not be temporary. Also, there's a statement in Owens, another statement, that was not the product of interrogation. They said in Owens that in that case, the statement about knowing this was going to happen was not the product of interrogation in this case. It is unprompted and unsolicited. The last words out of Townsend's mouth is, "We're going to wait right here for backup." No questions were asked, and then the defendant, unprompted, unsolicited, made a statement. He wasn't even saying the statement, if you look on the video, he's not even saying it to the police officers. It's more of an exclamation as he's walking away from them. He says this. So it's completely voluntary. Owen states that Owen did not make the statement in response to any questions, but instead volunteered the statement while two officers were searching the bag and talking to each other. Miranda would not apply to such an utterance, even if Owens made it while in custody. A defendant's spontaneous, voluntary, unprompted utterance to a police officer is admissible against him at trial. Do you want me to go through all the arguments or back and forth for each one? That's for the statement to Bazinet.
I mean, I'd probably prefer hearing it back and forth,
Okay.
unless that presents an issue for you all.
Just not none.
So, Judge, we would agree with the state regarding the whether or not the statement was voluntary does depend on the totality of the circumstances. And the voluntariness goes to the course of police activity as a necessary predicate to finding that a confession or a statement is not voluntarily or freely given within the meaning of the due process clause of the 14th Amendment. So when you take into account the totality of the circumstances surrounding these two brief statements that Mr. Gray made to Officer Bazinet, the circumstances are such that whether he knew they were temporary, whether he knew the detention was temporary, hasn't been shown. What has been shown is that he was under the belief that he was not free to go, that he was not free to use his phone, that he had been escorted from his home, moved to the outskirts of the property, away from the home, and that he had been surrounded, as you can see from the video, by many agents, what appears to be over 10, 12 agents or law enforcement officers in tactical gear with automatic weapons slung around their shoulders. So the question becomes, in the totality of those circumstances, is that enough for coercive police activity such that it overrides the voluntariness of any statement that he's given? And we would argue, just for purposes of these two statements given to Officer Bazinet, that it is, that based on his being told he cannot leave, he cannot use his cell phone, and being surrounded by agents in tactical gear with weapons, that does equate to coercive police activity, which is the predicate to finding those statements not voluntary given. And we would ask the court to suppress those two statements given to Officer Bazinet as not being made voluntarily.
Any final word on that, Mr. Sheen?
I do, Your Honor, but it blends into my next argument, which is that I was arguing the first statement to Bazinet. I think he was arguing both statements. The second one is just a consent. It's not a statement. It's just straight consent to search, which goes into the voluntariness. Again, you're looking at the same issues, the voluntariness of it, when he made that second statement. So it will be a rebuttal to the first, and it is my argument for the second one. My main case on that, Your Honor, is Brooks versus the state. This is a Supreme Court case decided in 2009. It's going to be, 285 Georgia 424. And in that case, Your Honor, it is well settled that a valid consent to search eliminates the need for either probable cause or a search warrant. So my next argument is going to be about the search warrant, but this consent eliminates the need for that argument at all. You don't need that search warrant. It doesn't matter. They talked about that wasn't, the consent to Bazinet wasn't conveyed to Agent Genta, but there's nothing in the case law that says the consent has to be told to every single officer. But because he consented to the search, that eliminates the need for either probable cause or a search warrant. Now, the state has the burden of proving that the consent was freely and voluntarily given under the totality of the circumstances, the same as the statement we talked about earlier. And in that case, Your Honor, there was nor is there evidence of coercive police activities. The uncontroverted testimony of the officer who conducted the search showed that Brooks was cooperative, even friendly towards him, and offered to assist him in locating the gun. There is no allegation that Brooks' age or level of intelligence rendered his consent involuntary. There is no showing that the officers misrepresented their authority to enter and search against Brooks' will if necessary. In that case, Your Honor, you can see that all the talk with the defendant is friendly, courteous. There's nothing in there that shows any sort of lack of cooperation. Batten versus the state is the next case, Your Honor. That's going to be 341 Georgia Appeals 332. It's a 2017 case. In Batten, Your Honor, the voluntariness of consent is determined by the totality of the circumstances. No single factor controls. The standard of measuring the scope of a suspect's consent under the 14th Amendment is that of objective reasonableness. And in that case, in Batten, Your Honor, there were several officers on the scene at the time. The defendant was not in handcuffs, and there was no evidence he was threatened, misled, or subject to lengthy detention. And that is exactly what we have in this case, Your Honor. That case also quotes Smith versus the state, which I don't have a copy of, but it's in Batten, which is 165 Georgia Appeals 333, a 1983 case, where consent was voluntary when the defendant was initially ordered out of his car at gunpoint, but police were no longer pointing weapons at him when he was asked for permission to search the vehicle. So even pointing the gun at you, as long as you're not pointing the gun at him when they give consent, that's still not enough to overcome the voluntariness of the consent. In this case, Your Honor, the guns were never pointed at him. Also, Your Honor, Batten versus the state says that once voluntary consent is legally obtained, it continues until it either is revoked or withdrawn. And in this case, Your Honor, there's no evidence whatsoever that he ever revoked or ever withdrew his consent. In fact, we showed evidence that even while the search was happening, he was still consenting to other searches. He was consenting to the search of his phone. So he never once had any sort of resistance that day to what police were asking. And he was voluntarily, throughout the day, consenting to searches of his house and searches of his phone. Berry versus the state, which is a 313 Georgia Appeals 516, is a 2012 case. And in that case, Your Honor, the court stated there's no evidence that prior to giving consent to search the vehicle, Berry was subjected to isolation from the others, prolonged questioning, physical punishment, or mental coercion. There is no showing that the officers misrepresented their authority to enter and search Berry's car against his will if necessary. Berry was about 45 years of age, and he made no allegation that his education and intelligence rendered his consent involuntary. Again, Your Honor, what they're looking for is flagrant misconduct by the police that overcomes a person's will to freely and voluntarily consent to things. Under Park versus the state, Your Honor, is a 2011 case, 308, Georgia Appeals 648. In that case, the court stated that Park suggests that the consents were given under coercion and duress since several officers were present and they had been held at gunpoint. So this defendant had been held at gunpoint, had been handcuffed, and placed on the ground during their detentions. Court went on to say that voluntary consent may be given while a suspect is handcuffed. And although approximately 6 to 8 officers were present at the scene, such did not require a finding of coercion. There is no evidence that the officers were acting in a threatening manner. In the audio recording, the officer spoke to Wilson and Park in normal tones and did not use threats or coercion. The trial court also has authorized to find that there was no evidence of flagrant misconduct in this case. And Your Honor, again, for this, what they're looking for is what's in the pattern jury charge. They're looking for something that's coercive, something that overcomes your will to voluntary consent. And if you watch the video, there's nothing in there at all, Your Honor. Still in Park, that the facts of our case, Your Honor, there's no duress. It's his home. There's no detention. Any words about stopping his freedom of movement implied it was temporary. It was in the first 4 minutes of their encounter. And it's just, hold up a second, wait a minute, we're just waiting for people to get here. And it's just trying to hold the status quo. This was a day. This was a crazy day. Everyone testified. They're running to this school, they're running to that school, they're running to this house. It was a day. These officers are there. Everybody just hold still for a second. And there's nothing that an objective person would think, oh, I am detained. I am been tortured. I have been threatened. I have been tricked. And therefore, I have to test. I have to give consent. There's nothing evidence of that, Your Honor. He was 53 years old. He had a job as a construction supervisor. His intelligence is not an issue. Everyone was being extremely cordial. We let the video play because there was a lot of talk about these officers with guns. We let the video play to show the interaction with some of these officers. Oh, your son goes to elementary school? Which one's that? Oh, is that here? And he's like, yeah, he's a rocket. He's the tug of war champion. And they're smiling at each other, shaking hands, being pleasant, being cordial. This was a completely voluntary encounter, and his consent was voluntary. It was never withdrawn or revoked. He kept consenting over the next 2 days. I know that the consent was given after this protective sweep, and a lot will be stated about the protective sweep. It's also on the video. All of this happens directly before the protective sweep, Your Honor. And Williams versus the state, which is a Supreme Court case, Your Honor, and that was decided in 2017. And that is 302 Georgia 474. In that case, Your Honor, a cursory warrantless search limited to spaces where a person may be found, known as a protective sweep, is permissible when officers reasonably believe, based on articulable facts known to them at the time, together with rational inferences drawn from those facts, that the sweep is necessary to protect or preserve life or to avoid serious injury to officers or others because of the potential presence of other dangerous persons or additional victims. We also have State versus Brennan, Your Honor, which is Court of Appeals case from 1996, 222, Georgia Appeals 372. And in that case, Your Honor, exigent circumstances allowed police arresting a suspect inside a home to make a cursory search of the house based on a reasonable belief that another occupant of the house might present an armed threat, upholding such a protective sweep to detect any immediate danger. Although we review police actions from the standpoint of a hypothetical reasonable officer, we must measure those actions from the foresight of an officer acting in a quickly developing situation and not from the hindsight which judges have benefit. And that's reiterated in Nelson versus the state, which is Court of Appeals 2005 case 271, Georgia Appeals 658. In that case, Your Honor, although we review police actions from the standpoint of a hypothetical reasonable officer, we must measure those actions from the foresight of an officer acting in a quickly developing situation and not from the hindsight of which judges have the benefit. Again, Your Honor, in this case, as Ned and the other officers, they testified, there's an active shooter at Appalachia High School. Everyone jumps in their cars. They are getting to Appalachia High School as quickly as possible. They're then diverted to Winder Barrow High School, where there's a threat of some sort of violence at Winder Barrow High School. They then divert to Winder Barrow High School and do a protective sweep there to make sure everyone's safe. They're then diverted to the elementary school, Bassinet testified to check on the elementary school, make sure everything's fine there. Then he's diverted to this house, Your Honor. This is a fast-moving, developing thing where lots of information is coming into these officers about threats and shootings and danger, and they do a protective sweep at that time to make sure there's no other people in the house. If you go back to Park versus the state, Your Honor, which I've already given to you, when it's talking about the consent, Park versus the state also says, even assuming the illegality of the initial entry and search, so even if you find the protective sweep shouldn't have happened, a party's subsequent consent to the search, which is freely and voluntarily given, may serve as an independent act of free will that purges the primary taint and authorizes admission of the evidence. The more apt question in such a case is whether granting establishment of the primary illegality, so granting that it was not supposed to happen, the evidence to which the instant objection is made has been come at by exploitation of that illegality, or instead by means sufficiently distinguishable to be purged of the primary taint. So what it's saying is, even if you find that the protective sweep shouldn't have happened, the consent after that cleans that, as long as they didn't use that to get the consent. And in the video, he comes out of the house. He's on the phone with someone else, not on the scene. No one says anything about what they saw in the house. Bazinet just walks up to him and says, "Hey, just to let you know, someone will be here to talk to you. We're getting a search warrant." And he voluntarily, without being asked, "Y'all don't need a search warrant. You can just go on in. We got nothing to hide." The protective sweep had nothing to do with him volunteering this voluntary consent. It's hard to say that you were coerced into consenting by law enforcement when no one in law enforcement even asked you to consent. You just volunteered it. Volunteered, root word, voluntary. Do you want me to argue the search warrant now or come back? Do you have a preference?
Do y'all have a preference?
Go ahead.
With the search warrant, Your Honor, same issue. You got to remember that with the consent, you don't even need the search warrant. But under State v. Palmer, which is a Supreme Court case, 285 Georgia 75, 2009, basically just gives the standards for what we're looking for when we're reviewing search warrants. And it basically says we begin by reiterating the standards applicable to the various levels of judicial scrutiny involved in the warrant process. The magistrate's task in determining if probable cause exists to issue a search warrant is simply to make a practical, common sense decision whether, given all the circumstances set forth in the affidavit before him, including the veracity and basis of knowledge of persons supplying the hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. The trial court may then examine the issue as a first level of review, guided by the 14th Amendment, strong preference for searches conducted pursuant to a warrant, and the principle of substantial deference must be accorded a magistrate's decision to issue a search warrant based on a finding of probable cause. Although in a particular case it may not be easy to determine when an affidavit demonstrates the existence of probable cause, the resolution of doubtful or marginal cases in this area should be largely determined by the preference to be accorded to warrants. So when the warrant's signed, the trial court, when you're reviewing it, are supposed to give a strong deference, a substantial deference to the magistrate's decision. And you're also to keep in mind, this is under State v. Palmer, keeping in mind that affidavits are normally drafted by non-lawyers in the midst and haste of a criminal investigation, which is exactly what we have here. This is not something where officers have been investigating this case for months and weeks and finally decided to go do a search warrant. This is happening quickly, unfolding, chaotic, and that's where this affidavit was drawn, Your Honor. But the affidavit is perfectly adequate. It states there's a shooting at the school. The suspect was identified as Colin Gray. He had been feeling depressed, made a list of mental health issues. He said in his statements in the affidavit that he wrote down his mental health issues. That's a writing. The writing wasn't found on him. It is reasonable to assume the writing would be at his house that he had left earlier that day. He had discussed plans on Discord. That's a computer program. Computers. He's discussing his plans. It's perfectly reasonable to assume there's evidence of that, evidence of motive, evidence of scheme in a computer in the house. He stated that he researched shootings on his computer. Again, on the computer, evidence of what he's been doing, his motive, his state of mind, all of that is evidence that the officers can go in there and look at. And the defendant was at the residence when the officers arrived and stated he was Colt's father, stated there were multiple guns in the house. Again, this is evidence they can use to then probable cause to go find boxes of ammunition that match the ammunition found at the scene. Gun cases that match the gun found at the scene. Similar magazines that match the magazines found at the scene. All of this is reasonable to assume that this evidence would be at that location. Under Franklin versus the state, Your Honor, I do have copies of this. This is 135 Georgia Appeals 718. And it basically just says that oral testimony can be given. The very last sentence, the oral testimony was sufficient to fill the deficiencies in the affidavit, and the trial court properly overruled the motion to suppress the evidence seized in the search resulting from the issuance of the warrant. The officer testified that he went to the swore to the magistrate, which was actually a Superior Court judge in this case, that this was the residence of the shooter who was in custody, and then that goes with the affidavit of what they found. Again, Watley versus the state also talks about oral testimony, Your Honor. This is a Court of Appeals case, February 335, Georgia Appeals 749, 2016. Again, basically just says that oral testimony can fill in the gaps of the written affidavit. And then again, Your Honor, we've already argued that the consent to search, which obligates the need for a search warrant, was not tainted by the protective sweep. Same thing with this, Your Honor, under the independent source doctrine, that if they're going to get a search warrant anyway, so we're assuming that you find that protective sweep was illegal. If they're going to get a search warrant anyway, and the search warrant was not because of something they found in the protective sweep, which is what we have in this case. Genta said he went to his job was to go get a search warrant, and that was what his assignment was, and he was going to the place to do the search warrant. So he was already in mind to do the search warrant before he was talked to the officers on the scene about anything they may or may not have found inside the house. So therefore, you would use the independent source doctrine under Tatum versus the state. That's a Supreme Court case, Your Honor, 2024, so it just came down last year, 319 Georgia Appeals 187. In that case, Your Honor, what they're saying is, as long as the search warrant wasn't gotten because of the illegal search, that what you would do is take out the things in the affidavit from the illegal search and go with just the things in the affidavit that you knew before that, and if there's probable cause, the search warrant stands.
So view this affidavit without the information obtained from the protective sweep.
Exactly. That's what Tatum says. But to get to that point, Tatum was trying. The reason it was a Supreme Court case was trying to go over two different tests that the 11th Circuit had that was different from other federals, and went with the 11th Circuit. And so the first test is you have to say that the getting of the search warrant wasn't because they found something. You can't break into a place, find something, and that's why you go get a search warrant. That's not the case here. Gents testified he was already getting the search warrant, and if you look, those things are added at the end because he had already started his search warrant, and that was just added at the end. So you take those out. If there's still enough evidence, the search warrant stands.
to be brief, Your Honor. This is kind of what we learned. We understand that the deputy, the first person on the scene, had gotten information, but not really sure exactly what that information might be. He got information from his lieutenant. He went to one high school, nothing going on there, then went to a grammar school, as we understand, and then ultimately was told to go to this particular location. When he got there, immediately he did a protective sweep. The thing that is bothersome is this was not any active crime scene. There was no crime going on there. The cases that the state gave you, for instance, the Berry versus the state, not any relation to me. In that case, they came to, I think this was a probation warrant that they came there to see him about. In the case of Nelson versus the state, when the police got there, they heard a commotion going on inside the house. They were afraid other things were going on inside the house, so that was the reason that they made a protective sweep. In the Williams case, similar kind of situation. There was a standoff in that case at the house. So once that got resolved, it was certainly wise to do a protective sweep. But that's not what we really have here. We have an officer that really doesn't know what's going on. He's been given an address, and he says that he does a protective sweep. What we learned later is that not only he does a protective sweep, but apparently there are numbers of other officers who go into the house as well. So it's not really a protective sweep at that point. If you've got 3 or 4 officers going into a house on a protective sweep, obviously it looks more like a search. And we know that's what it turned into be, because the deputy indicated that he saw a letter on the desk. And not only did he see the letter, he obviously read it, because he gave that information to the GBI agent who was getting the search warrant. That's a search, not a protective search or sweep. It's a search. So that's the first problem that we have. The consent, as the state pointed out, if you would call it a consent, was not, those words were not spoken until after that protective sweep had already been accomplished. Just go on in. We don't know under what context that was said. Nobody ever got a written consent. Nobody indicated that they spoke with him. It's interesting, too, that nobody told the GBI agent that he even said anything like that. The GBI agent, based on only information, we asked him specifically, what information did you have before you got the search warrant? His job may have been to get the search warrant, but you can't just go get a search warrant. You got to have a reason. You got to have a probable cause in order to get one. Well, what was that? What was the probable cause? Who did you talk to? What information did you get in order to get a probable cause? Well, part of that information was I read a letter, and he referenced it in the search warrant itself. So the officer based his search warrant on information that was gathered in a search that was improper. It was an illegal search at that point in time. It was not a protective sweep. If we assume, arguendo, that the protective sweep was, I'll just say bad,
do you agree that that portion of the affidavit has to be excised from it in considering probable cause, or does that taint the entire affidavit?
Well, Judge, we feel like that information obviously should not have been given to the magistrate. If the magistrate used that in his decision to issue the search warrant, then the search warrant itself is bad. Because if you give information that's bad in a search warrant, it invalidates it. I think we've all seen many instances where that has occurred. So we feel like, due to the fact that the GBI agent was given information that was fruits of an illegal search, then that would invalidate the search warrant itself. Because the only thing that the agent was going on is what other people told him, because he didn't observe any of these things. So that, we think, would certainly be a problem. And I think, too, with most of the cases that deal with protective sweeps, I just wanted to be clear, deal with active situations that are going on at the house, like an active crime scene. This was never indicated to the deputy that this was an active crime scene. Just go there. Apparently, he was not told what to do there. But when he got there, the first thing he decided to do was a protective sweep, along with all the other officers that went in. And I would adopt the argument as to the voluntariness also of Mr. Gray making the statement, just go in. We don't know exactly how, what context that is. We can't see everything that's going on in that video. We don't know whether somebody spoke to him. We really don't know much other than that one statement, just go in. Go into what? Go into the basement, go into car. We really don't know. And we will adopt the argument as to voluntariness of that particular statement. But based on these, and I don't believe any of the case law that the state gave the court really fit into this particular situation, because all of those were issues where there was something actively going on at that particular residence. They had no information that there was anything active going on there. They were told that there was nobody else in the residence anyway. So why do a protective sweep if there's nobody else there? Plus, why do you take so many officers in if it's not a search? Thank you, Judge.
Does it depend on any case law you want to review?
No, sir, just the ones that previously mentioned.
Did you have any final word?
Real quick, Your Honor, going to the search warrant and the consent. Park v. State, which I've already given you a copy of, just for the record, 308 Georgia Appeals 648. That's the one that said that even assuming the illegality of the initial search, so the protective sweep, assuming you should not have done it, a party's subsequent consent to the search, which is freely and voluntarily given, so subsequent to that, he gave his consent, freely and voluntarily, may serve as an independent act of free will that purges the primary taint and authorizes admission of the evidence. So if the evidence is found during this sweep that it's illegal, a subsequent consent allows that evidence to be admissible. And in part, it means admissible at trial. But if it's admissible at trial, certainly it's also admissible in the affidavit for the search warrant. So even if you think that there's some sort of break in the chain because Bazinet didn't tell Yenta about the consent to search the house, the defendant's consent to bassinet immediately coming out after the sweep to the person, one of the people that did the sweep, purges the taint of the sweep. So now that evidence that's found in the sweep can be used in the affidavit for the search warrant. That makes sense? And even if not, then you fall back on Tatum.
All right, obviously important issues. I'll be prepared to render a ruling based on what's been submitted, but if y'all want to do briefs, you're welcome to do them. Up to you guys.
Nothing further.
No briefs?
I don't think we need to do brief sessions.
Okay.
Thank you.
All right, so I'll get your ruling inside of the required 30 days. Then we need to talk about scheduling. We can do that. In chambers, anything else we need to discuss?
Not for the defense.
Okay. All right, we will adjourn for the day here. So let me make sure everybody is clear. So I know we have segments or portions of the video. Is anybody objective? I wanted to watch additional portions of what was admitted, but I can't.
No, the state would encourage you, if you have time, to watch all of it.
No, Your Honor, no objection.
All right. Thank you. Council, y'all want to come to chamber? We can get packed up and we'll discuss scheduling.
Does that work? Yes, sir.
Okay.